Can law enforcement officers invade a probationer's curtilage if they lock the gate? All right, my name is Anthony Bandiero, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing you a roadside chat. This question comes from an officer in California. So the officer says, look, I watched your video on curtilage. That's also on the channel. Please check it out. I think it's one of my most popular doctrines that I teach. The officer says, I'm employed as a probation officer in California and had a question regarding this topic. My unit conducts apprehension of probationers on warrant status. All right, so for the most part, they all have, it says Bravo search terms, which I don't know exactly what that means, but I think it just means a Fourth Amendment waiver, right? Probably a high level of a high level of ability to search their person, stuff under their control, and so forth, right? We have come across homes where the front gate is locked, thus preventing us from knocking on the front door. If we hop the fence to knock on the front door, is it breaking the curtilage rules, right? Do their terms have to specifically say that we can actually jump their fence? But it does. He also says, though, that their terms do say you're not allowed to lock a gate in order to, lock the POs out, right? All right. Here's my answer. The cops are going to be allowed to jump the gate, in my opinion. So, first of all, we don't treat probationers or parolees in the same way as the typical citizen, right? They have signed away some of their rights. Yes, they can do that. It goes like this. Do you want to leave jail or prison? The guy goes, yeah, I would love to get back out there and commit some more crime. And then the state says, all right, in order to get you out there, okay, you need to consider whether or not you are going to allow us to supervise you. If you allow us to supervise you, that means that we can pretty much, in many ways, treat you like you're still inside the big house. But if you say no, no problem. You stay here, right? So when the person consensually signs away some of their rights, they are then agreeing that the government has this authority over them that cannot be revoked, like consent. It now turns into what's called a special needs doctrine. Okay, so let me give you an example of this from a case called Griffin versus Wisconsin, United States Supreme Court. It says a state's operation of a probation system presents special needs, there it is, beyond normal law enforcement that may justify departures from the usual warrant and probable cause requirements. To a greater or lesser degree, it is always true of probationers, as we have said it being true of parolees, that they do not enjoy the absolute liberty to which every citizen is entitled, but only conditional liberty properly dependent on observance of special restrictions. Okay, I'll leave that quote in the bottom of the case, but that's what's going on here, right? The probationer is not going to be able to just lock their supervisors, their probation officers out by putting a padlock on the gate. The other thing that kind of adds a little extra oomph behind this is that this person apparently, according to, if I'm reading this correctly, has a warrant for violating their probation status. So that's going to give even more compelling need to go get this guy in custody sooner than later. But even without that, I think we're in the same boat, right? If that's the house that's on the paperwork and that's his residence and that's the one he agreed to be to have the search terms, he can't lock out police simply by putting the padlock on the gate, right? Otherwise, we defeat the purpose behind supervising these criminals before they have paid their debt to society. I hope it helps. Keep the questions coming. Until next time, my friends, stay safe and hope I have helped you get it right every time.